Hello, everyone. Welcome to our second podcast. I am having Mr. Riaz with me. Hi, Mr. Riaz.
Hello.
Today, the podcast is about the most popular category, which is 7 years childhood. So, can you please tell us what exactly 7 years childhood is?
So basically, the 7 year childhood is a concession which gives people the pathway to apply for either leave to remain or indefinite leave to remain for their child who has lived continuously 7 years in the UK.
Okay, so is it applicable on the kids who are born in the UK or for those who are not born in the UK?
So this route is designed for any parents who have brought their children in the UK, and the children either have born in the UK or they came with their parents, but they have lived continuously 7 years in the UK. So either of the parents in either of those scenarios can apply for under this 7 years concession policy.
Okay, so let's begin with the kids who are born in the UK and the parents had visa at the time of birth. What exactly would be their scenario after 7 years? What they would be applying basically?
So, depending if the child is born in the UK, whether or not parents had their visa continuously or they still have got the visa, so they can still apply for indefinite leave to remain for their child who has lived continuously 7 years in the UK. When we say continuously resident in the UK, that means that they have been living here most of their lifetime and they haven't exceeded 180 days in each rolling 12 months period. So that is a standard statutory requirement in most of the immigration applications. So if your child has been away for a shorter period of time, it will not still affect your application.
So when we are saying that it is shorter period of time, it means if they are having a tourist attractions visitors to another destination, or if they are visiting their own parents' country for holidays time, is there any specific time or number of days that they should be in the UK or out of the UK?
There is no specific number of days, but as I said, there is a requirement that if someone is away for more than 180 days, that might affect their continuous residency. So if a child has been away for a shorter period of time, which is less than 180 days, it will not affect their application. However, if in an unlikely event, if the child has been away for some good reason, that could be because they've been stuck due to travel disruption, if there has been some disaster in their home country, or there has been severely ill in the family. So that can be used as an exemption, but most of the lifetime should have been spent here while the child was in the country with their parents, and they've been, of course, studying or either into any education here.
As we were discussing that a child who's born in the UK can apply for settlement after 7 years, when he would be eligible to apply for nationality once the child who was born in the UK secured settlement?
Once the child has got indefinitely, because there are two scenarios. One is if the child has been born in the UK, they have lived here for 7 years. In such a case, child can apply directly for indefinite leave. If they were not born in the UK but they have lived here for 7 years, so in that case they apply for leave to remain. But once they complete 5 years on that visa, they can still apply for indefinite leave. But nationality is something which Home Office is granting only once the child either completes their 10 years lawful residence on the 7 years route, or once the child was born in the UK, they have completed 10 years in the country. So after they've even got the indefinite leave to remain, they may not be able to directly apply for citizenship. They might have to wait for another 3 years before they can apply.
That's perfectly fine. So in this scenario, you have answered actually two questions. That once a child who's born in the UK secured the settlement upon 7 years, he will be eligible for nationality after completing 10 years. The second stage that you have discussed for those kids who came in the UK with parents, completed 7 years, they would be eligible to secure their settlement after completing the 5 years on discretionary leave to remain. They would be granted for discretionary leave to remain after completing 7 years. Does it matter for the kids who came with the in the UK with their parents, and the parents have no visa at the time when they are completing 7 years?
As I said before, that it will not matter whether the parents had their visas continuously until the child has clocked 7 years in the UK. They could be without visa, they could be having no immigration status. So in either case, as long as the child has completed 7 years in the UK, they can still qualify.
Okay, that's fine. The second question that obviously has been asked, is there any fee waiver applicable for the settlement application?
Unfortunately, there is no fee waiver application that one can apply if they're applying for indefinite leave to remain. However, if you're applying for leave to remain, there is a policy, concession policy, that if you are subject to immigration control, you had no visa, you had no right to work, you were unable to make money while you were in the UK, or you fear a risk of destitution if you would pay that amount to the Home Office, you still can apply for a fee waiver exemption, which means that all the family members can be given a fee exemption, so there is no fee applicable in their application.
Okay, so discretionary leave to remain application has a fee waiver exemption, while the settlement application doesn't allow anyone to have the fee waiver. Is it correct?
Yeah, that's correct.
Okay, so if you mind telling us about what sort of documentations are required at the time when they are submitting their 7 years child application?
So basically, what you have to prove is that child has lived continuously in the UK, and the best interest of the child is to stay in the UK, and the family should not be removed. So starting from the point when the child entered the UK, if they started their education from let's say from nursery to secondary school or a high school, so you have to include all the school records, any let's say family gatherings, if the child has been away on a trip, they have got any certifications, any achievements they have made. So you can include all sort of evidence, including if the child was born in the UK, you can include their red book evidence from the appointments with your GP or a doctor. You can include all of that evidence to compel the Home Office to make a decision in your favor, because you are proving that the child has lived here, one condition, and the second is the best interest of the child is in the UK, and they should not be removed.
And this scenario, these kind of documents are applicable on both the kids who are born in the UK or who are not born in the UK?
It's applicable on either of these applications, so no matter where the child is born, if you're making this application, you have to include all these evidence.
We have also questions about expert reports. Does expert reports play something most important or put some weight towards the success of this application?
In cases where if a child has lived, let's say, their cognitive initial years in their home country, in such cases, we recommend having an occupational therapist report, let's say, a child psychologist or a psychiatrist report, or a social worker's report if their children are over, let's say, at the age of 16. So we recommend including such reports. But as I said, if you can have other evidence included, like most of the family is here, the child has been studying here, or if the child has special needs, you can include those expert reports as well.
We also encounter another frequently asked questions by the parents of the kids at the time of when they are applying for the settlement of the kids. Can they apply for the settlement at the same time if they don't have visa?
In both cases, whether you're applying for indefinite leave of your child or you're applying for leave to remain, if the parents are going to complete their lawful 10 years residence, of course, they can go for indefinite leave, but they will not qualify for ILR along with their child. So they must complete their own lawful residence. Where if they had a visa, so they complete lawful 10 years residence. If they don't have a visa and they're getting first leave to remain as a parent under this route, so they have to clock 10 years time to
So-
apply for indefinite leave.
So it means that if the parents don't have visa and they have discretionary leave to remain on the basis of the child, so they have to make sure that they complete 10 years from that point onwards.
That's correct.
The another question that comes with this scenario is that if the parents are applying for indefinite leave to remain after completing their 10 years of lawful residence, will the child would be eligible at that time who has already secured for the settlement at the time of 7 years, he can qualify for the nationality if the child is born in the UK?
If the child is born in the UK,
And the parents are applying for indefinite leave to remain after completing their 10 years of lawful residence in the UK.
of course, in such a case, if the parents get settled, either of the parents get settled before the child is qualified, so you can apply for nationality, because if your child is born in the UK, you can register them as British citizen if either of the parents get settled.
Thank you so much for having us today, and we will see you next time.
Thank you.